So another question here. There are two visas in L1, like L1A and L1B. Are they both same, or are they different? If different, how are they different actually?
So an L1A is a multinational executive. And an L1B is a person of specialized knowledge. So completely different actually. An L1B is not someone working in an executive position. What the company is saying is we are transferring him from our foreign entity to our US entity because he has specialized knowledge of our product or our processes. That's an L1B. So you see most of these MNCs, they use L1B in lieu of H1. And the way they justify this is generally they'll say that, okay, from the past 1 year, they have been working with client XYZ on this project. So they have unique knowledge of the product. And for us to hire someone else and teach them about the environment and the product is going to take time. Therefore, that's why the L1B was instituted. But they have to prove it, that the person actually qualifies for an L1B. And in order to file an L1B, you have to show that there is something unique in the company's product or processes. For example, you're using some kind of a technology or software which is unique. It doesn't have to be proprietary, but it has to be somewhat unique, which means that it doesn't have to be, if it's proprietary, that's great, because then it's difficult to show that anybody else will have that knowledge. But it has to be something at least that is not easily, if you're using CMM, in the past years, they would say that that was a particular process, CMM process. And that was not very commonly, the knowledge, it wasn't known commonly. So you'd have to get a certification to, get knowledge on those processes. So they would use that and twist it and say that, we're using these processes, but we have modified it in a certain way and we're using a modified version of it. And this beneficiary has that unique skill and has actually worked on these processes, and therefore we need them to come here and work with our client in the US. Or you can say that they worked previously with the same client, but now they're physical, they have to be physically present in the US at their client site, and therefore, we need them to come here. So the good thing about the L1B is they can work at the client site. They don't have to necessarily work at the company office. They can work anywhere. And as I was saying to you that there's no salary requirement, minimum or maximum. So a lot of MNCs use these L1Bs. And the other good thing about the L1B is blanket petitions can be filed. Provided that certain requirements are met, a company can apply for a L1 blanket petition. And what happens with that blanket petition is then each time they have to bring someone in, they don't have to apply with USCIS. They don't have to file an I-129. They have to go directly to the consulate and fill out the I-129 petition and everything, but they have to just take it to the consulate, and the consulate will decide whether this person qualifies for an L1B or not, and they're allowed into the country. So it becomes much, much easier when you don't have to go through USCIS and you're going directly to the consulate. So, but in order to qualify for a blanket, there are certain requirements that have to be met. So basically, the first thing is, of course, the relationship has to exist. A parent, branch, subsidiary, affiliate. It has to be a qualifying organization. Both the companies have to be qualifying organizations, and then the petitioner and each of its entities are engaged in commercial trade or services. So they're into a certain business. And then the petitioner has an office in the United States that has been doing business for 1 year or more. So that's important. That is not a requirement for the L1A. It can be a startup, but for an L1B, you have to show that the US office has been open for at least a year. And then the third requirement is that the US office, the petitioner, has 3 or more domestic and foreign branches or subsidiaries or affiliates. That means they should have 3 other entities around the world. This cannot be the only organization. This organization, of course, the foreign organization has to be there, the parent. But in addition to that, they have to have 2 more organizations. branches in other countries, I guess, would suffice, or affiliates or subsidiaries, whatever it might be. They have to have 3 other organizations. And then most importantly, the petitioner, the US company, and the other qualifying organization has obtained approval of at least 10 L1B petitions. So first you have to file 10 L1B petitions, and they have to get approved. Then you qualify for a blanket, otherwise you don't. So and that has to be done during the previous 12 months. So it's quite a stringent requirement, and that's why only big companies can usually qualify for blankets. And more importantly, the combined annual sales has to be 25 million. And US workforce, 25 million, or a US workforce of at least 1,000 employees. So as you can see, small businesses will not qualify for L1 blanket. They can do L1B individual applications and of course L1A applications, but for blanket, you have to be a large organization. So that's the story with the blankets. And you have to remember the L1 blanket is usually more difficult to get approved, especially if you're filing an individual case when compared to the L1A, because to prove specialized knowledge is always more difficult.